I am, yeah, thanks, Brian.
Okay, thank you. All right, welcome to the Marshfield Zoning Board of Appeals, September 9th, 2025 meeting. This is a hybrid meeting. If you're dialing in on a phone, please use *6 and mute and unmute. So for tonight's meeting, I'm going to start with Heidi Conway and Brian Sullivan are no longer members, just thanking them for their service. And I'm going to do a roll call since I'd like to introduce Steve Lynch and Eric Murphy, our two new members to the board. So we'll do a roll call tonight. So name and present.
Larry Keane here.
Steve Lynch.
Grove Hensley.
Brian Murphy.
Mac Brothers.
Jean Lee.
Eric Murphy.
Thank you. And since Heidi's gone, we do no longer have a vice chair. So I am going to make a motion that Grover Hensley be the vice chair. Do I have a second?
Larry Keane, second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean
Eric.
Lee, aye.
Eric Murphy, aye.
Thank you.
Thank you. So, and we're going to go out of order because we're going to just do the continued and the withdrawals first. So in case anyone's here for those, they can at least leave. So we have 2553 Matthew McLean. Petitioner is seeking a special permit in accordance with 305-10.02 of the Marshfield Municipal Code to construct a 16-foot by 17-foot 6 three-season room where the previous deck was located on the property located at 145 Stagecoach Drive, which is further identified on the assessor's maps as being on parcel J040315, located in the R1 zoning district, and the Water Resource Protection District, WRPD. They would like to withdraw without prejudice. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
So now we have 2554 Armstrong Family Trust. In accordance with 305-1009 of the Marshfield Municipal Code, the petitioner is seeking an appeal of the building commissioner's denial of permit, alleging the location proposed on the pool shed does not conform to dimensional requirements, and a variance 305-1011 for relief from 305-607, accessory buildings to construct a 10-foot by 20-foot pool shed on the property located at 33 Reeves Road, which is further identified on the assessor's maps as being on 112-0202 and is located in the R1 zoning district. Petitioner is requesting the withdrawal without prejudice. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
So now we have, in the continued hearings, we have 2523 Equitable Development LLC. Petitioner requests to continue to October 28th, 2025. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
And now we have Dana Jr. in the continued hearings, 2544 Dana Jr. Petitioner is requesting withdrawal without prejudice, 37 Malden Avenue. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Then we have 2545 Dana Jr. Trustee Dry Seal Trust, 605 Plymouth Ave, is looking to continue to Wednesday, September 24th, 2025 meeting. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
And finally, we have 2549 Mill Pond Realty Trust, requesting 835 Plain Street. Petitioner requests to continue to October 14th, 2025. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grove Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
All right, now we can get back to the beginning. So we have 2550 Town of Marshfield. Who's here for that? Oh, come on up. The petitioner is seeking site plan approval 305-1202 of the Marshfield Municipal Code to expand South River Park, which is currently located at 2148 Ocean Street, include the .489 acre parcel of land, 2160 Ocean Street, which is further identified on the assessor's maps as being parcel G08, 0502, and is in the B2 zoning district. Go ahead.
My name's Susan Karen. I'm the chair of the Open Space Committee, and I'm here to seek site plan approval to expand South River Park to include the Ocean Street. This is part of a larger park project that's been going on for almost 20 years now, where the Open Space Committee is trying to improve environmental conditions along the South River where we can. There's a lot of degraded properties that could benefit from being restored and be better buffer zones to the river. And additionally, it gives an opportunity to improve the aesthetics of the downtown area, but also provide public access. And due to topography and a variety of things, we can completely ADA public access, which is what we have done on South River Park. It's always been our goal to hopefully acquire the property that we have now, which we acquired in 2023, to extend the ADA walking paths to provide a natural park and views of the river. I think most relevant to you is that we're not having any parking on site. The existing parking entry, that driveway entryway will be restored, but not open to the public. It'll only be for maintenance vehicles and emergency vehicles only, and they'll have a swing gate there to prevent access. Pedestrian ADA access will be from the existing park, as is the parking lot that's got 10 parking spaces in it, ADA parking space as well. You can access the 2160 Ocean Street entryway. There is a walkway that will go parallel to the parking lot, the driveway, but that's not ADA accessible because of the slope. It's outside of the floodplain. We've received approval from the Marshfield Conservation Commission. The goal of the project, the conservation goals are to restore the site, the degraded landscape and replace with native plantings that would be more appropriate for habitat. And the degraded landscape will also improve stormwater runoff for the river. And that's all I have to say at this point. Is there anything else? Any questions?
I have none.
This looks awesome.
Anything from the board?
It's a no-brainer.
It's gonna look substantially better than it does now, that's for sure.
That's what we hope to do.
The only question I had is, in your application, you mentioned having to move 1,000 cubic yards of fill.
Yes.
Why doesn't that trigger a special permit requirement?
In this instance, it did not require a special permit because we're required to do this. There was, this phase two, there was a phase 2 21E subsurface soil investigation that it's, because they found discovered coal ash, best management practices require the addition of the fill. So this is meant to be a clean cap cover over
Very
to
nice.
prevent public exposure to the affected soils. And that's over a geotextile marker layer, and then there'll be loam on top of that. So it's sloped, none of the fill is actually in the floodplain, but it's gradually sloped so that it doesn't affect runoff to the river. The way they've landscaped it is that they'll be, all runoff will be from impervious areas to pervious areas to have, mimic normal hydrology, basic to the landscape to drain. So that's, I don't know why we didn't have to have a site plan.
No, it's, don't disturb
So
it.
this had a bad 21E on it?
Yes, the only thing that was discovered was coal ash.
sorry?
Coal ash was discovered, which is
Yeah.
very common in redeveloped parcels, in soils like this.
Yeah.
So, but there were no other substances that were DEP reportable, and the coal ash is not DEP reportable, but they do have best management practices that, so we have a soils management plan.
So bottom line, this project will help clean that up.
Absolutely, we'll cover it, yes, absolutely.
Will contain it.
Yes, it contain it, and areas where, as you get close to the river, where we can't add fill, it will all be a vegetative cap, native plantings just around that area, things that will prevent people from accessing it.
Yep.
That's how the plant selections will do that, and it will be designed for that effect.
Thank you. Anything else from the board? Anything from the audience? Andrew, other than your notes, do you have anything to add?
No, I've met with Susan about this and gone over it. I also think it's a great project, great use of that space, especially from what it was, which was, a dilapidated building that I used to get a ton of complaints on. So I'm all for it.
All right, awesome. Okay. Seeing that there's none, I'm going to move that we close 2550 Town of Marshfield, 2148 Ocean and 2160 Ocean Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Rob Ramsey, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
I'm going to move that the board vote to grant the petitioner's application for site plan approval, subject to the conditions. The board should require a copy of a final as-built site plan that will be submitted for the Conservation Commission for the certificate of completion. Also be submitted to the ZBA for their records for the project is complete, as there are no building or floodplain permits associated with this project. Based on the findings that the applicant's proposal to expand South River Park, which is currently located on 2148 Ocean Street, include .489 acre parcel of land at 2160 Ocean Street as described on the application for site plan approval dated August 7th, 2025 by Susan Karen, Chair of the Open Space Committee, and Form 2D requested findings fact for site plan approval dated August 6, 2025 by Ms. Karen, shown on the permitting drawings of South River Park expansion dated August 6, 2025 by Niche Engineering, Shadley Associates PC, Lucas Environmental LLC, 15 pages, and the colorized landscape plan labeled site plan dated August 6 by Shadley Associates PC, 1 page. Meets the performance standards and design objectives of 305-1202 of the zoning bylaw. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Rob Ramsey, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Thank you.
Thank you.
Thank you very much.
Brian, pardon me, did you address the jetty? Is the jetty continuing?
I missed it, so, I mean, I guess I could do it now.
Yeah.
Which number is it, so I don't,
2534.
what is it? It's in the continued hearings, right?
Yep, second page on that one.
Second from the top.
Oh, sorry. So I'm going to do C, 2534, the Jetty LLC, 278 Ocean Street. They're looking to continue to 9/20/24? Wednesday, 9/24. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
I can't vote.
Oh,
Rob Ramsey, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Thank you. All right, so now we're on to B, David and Amanda Pratt. Petitioners are seeking a special permit in accordance with 305-1010, 305-1012 of the Marshfield Municipal Code to construct a 15-foot by 17-foot single-story mudroom on the northeast side of the property located at 27 Tupelo Road, which is further identified on the assessor's maps as being on parcel 1140316. It's located in the R1 zoning district, water resource protection area. Go ahead. Name and address for the record, sorry.
David Pratt,
Amanda Pratt.
27 Tupelo Road, Marshfield, Mass. 02050.
Thank you. Go ahead.
Yeah, so we're just looking to add a 15 by 17 mudroom addition to the northeast side of the house. This is a non-conforming lot, the southwest corner of the house, so it doesn't conform to the side and front setbacks. But on the opposite side of the house, it looks like we have plenty of room to put a 15 by 17 foot addition, mudroom addition on the house. We have 3 kids, and we're looking for a place for everybody to be able to drop their stuff when they come into the house, instead of in the kitchen or in the front vestibule.
Okay. Andrew, do you want to add anything other than your notes?
No, I don't know if you all read the associated notice of violation, but I wanted to be clear that we've gone over several of the issues, and the only issue that they had left was to go through the special permit process. But otherwise, it's kind of just the fact that the process got missed. But the actual addition conforms to all setbacks.
Thank you. Anything from the board?
Looks very straightforward to me.
I just have a question for Bob, actually. So I was just wondering why it has a 1010 in there. I mean, that's a use, right? And then out of the use table.
I think it's the general special permit provision. This is a 10-12 thing. I think it's a mistake.
Okay.
In what's in here. But I do think it's a mistake that the board can correct on its own if you choose to do that. Should be under 10-12.
Okay.
So take 10-10 out altogether.
It's in the answer.
The relief is the same, it's just the wrong section. Yep.
Anyone else? Anyone from the audience? Okay, seeing that there's none, I'm gonna move that we close 2551 David and Amanda Pratt, 27 Tupelo Road. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Back Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Congrats.
Thank you.
Yeah, well, wait, so now we're gonna move that we approve, board grant the petitioner's application for a special permit, subject to the conditions. This project will require a demolition permit for the removal of the foundation elements, compliance with the performance
Oh,
standards.
Brian, sorry.
Yep.
Make sure you're reading the right one. That was if it was not gonna be approved.
Oh, yeah, you're right. So it will receive a, this needs a building permit, a final as-built site plan, and certificate of occupancy. Based on the findings that the applicant's proposal to construct a 15-foot by 7-foot single-story mudroom on the northeast side of the property located on 27 Tupelo Road as shown on the elevation plans by Custom Home Designs dated May 9th, 2024. 3 pages and site plan showing proposed home addition on December 14th, 2023, Morse Engineering Company Incorporated. Jason Scott, PLS, 1 page, meets the special permit criteria of section 1012, thank you, Steve, of the bylaw. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Back Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Thank you.
Thank you.
Thank you, everybody, appreciate
Have a
it.
good night.
You too.
So now we have Sean M. Conley. Petitioner is seeking a special permit in accordance with 305-1012 of the Marshfield Municipal Code to construct an 18-foot by 36-foot addition on the property located at 355 Plain Street, which is further identified on the assessor's map as being on parcel F090123, and is located in the R1 zoning district and the WRPD. Go ahead.
Sean Conley, 66 Sherman's Way, Marshfield, Mass. 02050. I am the general contractor on behalf of Michael and Kelly Frazier, that are lifelong Marshfield residents. They live in this house at 355 Plain. And we are trying to remove the existing garage and add some living space for them, as they just had their 3rd child, and it is getting very tight in there. So we had some issues at the beginning with some setbacks. I talked with the customers and said that we need to shrink this thing up a little bit to conform with the setbacks, and even though they still were in a non-conforming lot, so we needed the special permit for that. We still shrunk it in to be less than the 20-foot required setback on the side, where we are gonna be doing the addition.
Okay, and Andrew, you reviewed the new plan here, and you're comfortable with it?
He's missing.
Not at his desk.
All right.
So, any questions from the board?
No. Very straightforward.
Any questions from the audience? Seeing that there's none, I'm gonna move that we close 2552 Sean M. Conley, 355 Plain Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Back Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
I move that the board vote to grant the petitioner's application for a special permit, subject to the conditions. It will be a building permit, final as-built site plan, and certificate of occupancy. Based on the finding that the applicant's proposal to construct an 18-foot by 36-foot addition on the property located on 355 Plain Street is shown on a progress set of plans by Rockwood Design dated June 26, 2025, 14 pages, and the proposed foundation site plan, June 21st, 2025, by PGB Engineering.
Oh, Brian, you gotta change that.
What did I gotta change? Oh, yeah, the plan's different.
That's the old one.
Yeah. What's the new date? So,
It's August 7th.
8/7.
so plan dated 8/7/2025 by PGB Engineering. Meets the special permit criteria of 1012 of the bylaw. Thank you. All right, so now we're on to.
I want to second it.
What was it?
I want to
Oh, second.
Second.
All in favor?
Larry Keane, aye.
Steve Sunshine.
Grover Henslee, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Thank you.
Thank you.
So we did those, we're on to F. 2555, Old Alley LLC. The petitioner is seeking a site plan approval under 305-1202 of the Marshfield Municipal Code to construct a 19-foot by 31-foot pergola over the existing concrete patio used for outdoor seating on the property located at 93 Central Street, which is further identified on the assessor's maps as being on parcel M06-1001, is located in the R3 zoning district. Name and address for the record.
Rick Savant with Stenbeck and Taylor.
Thank you. Go ahead.
David Bostwick,
Pardon me, one second.
owner of the Point
Ryan,
Restaurant.
I'm gonna have to recuse myself because I can vote fairly on this, I believe. But just to make sure there's no problems, I did receive an abutters notice for the business that I run on that street, so I'll recuse myself.
It's okay. Thank you, Steve.
Yep.
Go ahead.
Okay, I did have a quick handout. I just wanted to give you some bit of what we're looking at here. So even just real simple, I just wanted to, I think you got a good picture.
I already have that
We
anyway.
can share it, that's fine.
So what we're proposing down at the Point Restaurant at 93 Central is a pergola over an existing outdoor dining area. I don't know if you're familiar, if any of you have been down there. I'm guessing some of you have. They have an existing patio off to the west side of the restaurant now that is currently used as outdoor dining. You can see it there. It's got lighting, fencing around it. It's on a concrete patio. What they're proposing and what they'd like to do is provide a little bit more shade and protection there for the diners. They're proposing a pergola, as you can see on kind of page 2 as an example. It's an aluminum framed structure. It's detached from the building. It has like a louvered roof for sun and shade when needed. It's the same footprint as the existing concrete patio there. It's seasonal. The restaurant closes in the first week of November, so it's not something that's going to be open to the winter, through the winter. It's open-sided, just basically a roof structure over the dining area. It does have some exterior lighting. It's low-voltage LED lighting, which there's you can see on maybe page 3 of that little handout I gave you. There's one on the center beam shown there, but it's basically downward-facing low-voltage LED lighting. A little different than what's out there now, but certainly no outward-facing lights. There won't be any change to how the restaurant currently functions over there as far as parking or off-street parking or loading or anything like that. There won't be any changes to the way that it functions as far as pedestrian movement or just general function of the restaurant. So we're seeking a site plan approval for that. I have reviewed it with Andrew, and we looked at some of the different aspects of it, but we're basically looking to provide some protection over that patio. So I'll stop there and answer any questions you might have.
Is
Anyone
that
from-
glass in there between metal?
No. So I gave that as an example there. It's a very similar layout. We're obviously not going to have those brick columns, as I noted. But there'll be some roll-ups, vinyl sides on this for protection.
Yep.
But no, just basically open
Well,
6x6 posts.
With the roof area in between the metal.
In between the meadow where the fence is located, where the fencing is currently now on the post, we're gonna have the Atlantic, they're gonna do the stainless steel railings with cables.
Yep.
So the roof is a louvered roof.
Yeah.
So they have the ability to open and close it like that, but there's no glass
Okay,
in
yeah,
between.
I get it
It's
now,
just,
yeah,
yep,
right.
yep.
It's nice.
Any other questions? No. Anything from the audience? Andrew, you have anything to add, or other than you?
No.
Thank you. All right, so I'm going to move that we close 2555 Old Alley LLC, 93 Central Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Ike Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
I'm going to move that the board vote to grant the petitioner's application for site plan approval, subject to the conditions. This will need a building permit, final as-built, plan, and certificate of occupancy. And, no, doesn't need a certificate, that's right.
Compliance with the floodplain bylaw.
Compliance with the floodplain bylaw. Oh, I read that. So this project will require compliance with the floodplain bylaw, a building permit, and a final as-built site plan. So, subject to the conditions that I just said, based on the finding that the applicant's proposal construct a 19 by 31-foot pergola to cover the existing concrete patio used for outdoor seating on the property located at 93 Central Street, also known as The Point, as detailed on the footing detail plan by Engineering Express dated August 24th, 2018, and last revised August 19th, 2021, showed a certified plan dated August 5th, 2025, and revised August 13th, 2025 by Stenbeck and Taylor, Richards Savant, PLS, meets the performance standards and design objectives of 305-1202 of the bylaw. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Ike Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
All right, so now thank you, guys.
Excellent, thank you very much.
Thank you.
So now we have 2542A, Matthew Bruce, trustee, Bruce Family Realty Trust. Petitioner is seeking a special permit in accordance with 305-1010, 305-902, 305-905 of the Marshfield Municipal Code, for after-the-fact permitting existing on ground-level deck on the property located at 8 Ocean Street, which is further identified on the assessor's maps as being on parcel N060523, is located in the R3 zoning district. Go ahead. Name and address for the record.
Good evening. My name is Adam Brodsky. I'm a local land use and environmental attorney with DTM Law in Hingham. And this is Matthew Bruce, the trustee of the Bruce Family Realty Trust, which owns this property. We were last before the board on August 12th, and at that time, the board may recall, it was prepared to consider our request for a variance to retain the existing walkway that's located within the side yard setback. But at that time, Mr. Stewart received a photograph which seemed to show, or which did show, excuse me, a landing which existed prior to the construction of that walkway by the prior owner. Again, Mr. Bruce and his family had nothing to do with the construction, but suggested that, in fact, there was an existing non-conforming structure within the setback, and suggested that in lieu of a variance, that a special permit may be appropriate. Indeed, the board asked that we submit a special permit application, which we did. We thank you for consideration of the staff. We literally got it in the next morning to get on this agenda. I do note, and thank you for one of the board members, I think we erroneously cited to 305-1010 when it probably should be 305-1012, since it's an extension of a pre-existing non-conforming structure. So we request that that change be noted in the record. Again, authorization of this existing walkway by special permit as opposed to a variance will not be substantially more detrimental to the neighborhood than the existing structure. Procedurally, you may remember that this started with a notice of violation of your floodplain bylaws, as well as other zoning requirements relating to dune resources. Mr. Stewart recognized the structure is not located within the floodplain and indicating his willingness to withdraw that notice of violation. If the board is willing to grant a special permit, we would request the withdrawal of the variance application, because that would be moved. So I think that cleans up the procedural record. So I'm happy to answer any questions. It's the same structure, the same project, we're just changing the form of relief.
At the time, during the last meeting, both parties had two different surveyors coming in to survey. How did that end up? And do we have any?
That has not been resolved. That's going to have to be resolved again. We provided a stamp plan by our surveyor indicating where we believe that the property line is, upon which the board can rely. And to the extent that there's a property line dispute, the parties are going to have to resolve that outside of the zoning process.
Bob, are we allowed, so if the neighbor has presented something that's conflicting to this, are we able to still grant a permit based off of their,
If the neighbor presents what,
like a conflicting plan?
I thought there was a photograph that was pretty clear as to what existed before. If the neighbor presents something conflicting, you have the ability to assess whether you believe that that's true or credible.
I don't want to, what I'm trying to say is I don't want to grant something and then have it come back in 3 years. Like, if we grant this today and there is a conflict, is that handled outside of
If the
here?
neighbor disagrees, the neighbor always has appellate rights.
Okay.
So it won't last for 3 years.
Yeah.
The neighbor will
Lisa.
either agree and allow this to stand, or the neighbor will appeal and challenge the board's decision.
Okay.
What Attorney Brodsky has said tonight is accurate. We discovered that there was evidence that was a prior landing, which meant that the structure already violated the side setback requirement. So his request to amend and ask for a special permit obviates the need for the variance, which we were going for when he was here the last time.
Yep.
And I think with the notation that he's made, 1012 is the right section of the bylaw, and we won't be arguing about this in 3 years.
Good.
It'll be over tonight, and
Yep.
then if the neighbor
And next.
disagrees with the board.
Next meeting.
I think what Grover was getting at originally was, one of the plans showed that the deck was actually on the neighbor's property.
Yes, sir.
So would we be able to, if that is factual, if it comes out that the neighbor's deck is, this deck is on the neighbor's property,
Yep.
and that is confirmed,
Yep.
could this,
Bob, you got to
amended
turn on
that
your
they would
mic.
have to, limit it to their property if they had to reduce the size of the deck at a later date?
That could happen, but remember, your board doesn't have the authority to determine where the lot line is. So all you can do is take the application that's presented and the information that you're given regarding where the lot line is from the applicant. And if you believe that that sounds reasonable, where the lot line is and what the impact is will be decided in another forum, probably by a court if they can't agree.
So there'd be no language in this saying that if that is determined, the deck would have to be.
I think you should stay out of any determination as to where the lot line is because you don't have any legal authority to make a pronouncement on the issue.
Didn't we say that we wanted both the surveyors to come back and figure it out?
They talked, I believe they talked.
And nobody has,
It
it's still
It
different.
has not happened, but I guess to town council's point, if that lot line changes, my client has two choices. One, he can remove the encroaching portion of the deck, or come back and, I guess seek a modification. Again, we can't put a structure on someone else's property.
I mean, can we put a condition on this special permit that if the deck is found to encroach on the abutter's lot line, that it has to be trimmed off to fit? And that way it's not coming back to us?
Well, as a practical matter, that's exactly what would have to happen. If you don't think you would approve the project, if it's determined that the deck is over the lot line, you could also say, and then if it's determined in another form that the deck is over the lot line, the board will accept so much of the deck as remains within the lot line if you want. Or, you could, conceivably, you could ask them to come back here and get a further approval if it's determined that the deck is not on the property. You could do one of those two options.
So I might suggest it's really not necessary, because if we're in a dispute and ultimately it's determined that we have a portion of our deck on someone else's property, that's going to need to be removed. So it's self-enforcing without the board having to get into the middle of it.
Yeah, but you might have to come back for another special permit, right? I'm trying to obviate the need for that.
So I don't think we would need a special permit. We have a special permit for the deck. If the
Okay.
board, if Mr. Stewart determines that we need a modification of the special permit so that that issue's closed out, we're certainly more than willing to do whatever we need to do to resolve this. Again, this is not an issue caused by my client. We're just trying to fix it.
No, we're making, it's a.
And you've been great. I don't mean to suggest otherwise.
It's the hard way to do the right thing.
Yeah.
Right.
Totally agree, but also, we don't want it that your deck ends up being a foot on your neighbor's property, and now your neighbor's fighting you to get off the property, you know?
And again,
So
we-
if
we-
that's-
we-
if that's your- if your client, if the applicant is saying that if he ends up being ultimately on somebody else's property, that he would voluntarily remove that, is that what you're saying?
He's going to have to.
He has no
because
choice.
That would be land court.
Not
But so-
exactly true, but anyway.
Go ahead, Steve, you want to say something?
So the case law on something like this is pretty variable. There's some cases where the judge has ruled that the neighbors should come to an agreement with each other where you should buy that little piece of land from them.
So there are many different resolutions. One, my clients may have a claim of adverse possession over a portion of that property, so ultimately they may
How
acquire.
long has the new deck been there?
It's not long enough.
So it doesn't reach.
But there was an
new deck,
existing, there was
the
an
new deck.
existing structure.
Not the old deck, the new deck. How long's the new
Since
deck been?
No, it's recent.
It's recent, okay, so,
But there's a, in addition to the deck, there's a fence. So so there are a bunch of different ways that the property line dispute can be resolved. Hopefully the surveyors can figure this out and the parties can reach some agreement. They can reach some other property agreement. They can, reach an agreement regarding an easement. There are, prescriptive rights in the land court. I'm suggesting we are going to be compelled to resolve that, but I don't think this is the place to do it.
I agree.
So, from the audience? Oh, sorry, you're not done, Steve.
so even if it's adverse possession, which I don't think that it is,
Time spent since the 19th, so they don't have, done 2019, so they don't meet that
But
time.
again, there's a fence further. It's more complicated than just looking at the wall.
so the cases that I read, the judges like to let the parties work it out.
Yes, sir.
And so, the two parties can't work this out? You're not willing to remove 1 foot of that walkway? And one other question, so even if it was resolved where your surveyor is correct, the new deck that was built is still within the setback though, right?
Which is why we need a special permit, yes, sir.
I get that, so, okay, I'll hear from, you can hear from the other person.
Well, we want to hear from the audience.
I believe that a special permit at this point is moot.
Name?
Oh, sorry.
Oh, I'm sorry. I've been up here for a while. I'm Pat Banda. I'm the abutter. I'm number 4 Ocean Street, Grand Rock.
Okay, thank you.
Sorry. So I feel a special permit is moot because number 8 is asking for land that doesn't belong to him. I've got pictures that you probably have seen that show that the deck is 5 inches onto my property. I've got 2 surveys, one of number 8, one of number 4, that say that that property line that I'm maintaining as mine is correct. So I have 2 surveys. We've had another survey introduced by Mr. Bruce that was, they came out in, the numbers on the survey are they came out in July, they came out again in October, they finally issued, or they came out in October, they came out in December, they finally issued it in July. That surveyor has, Mr. Servant has been willing to meet with the surveyor. It hasn't happened. So
So this whole thing is about 5 inches of a deck?
5 inches and a setback. If,
Okay.
are there
And the deck
pictures?
was
Do
built
you have
before?
access
I
to
just want to
those
recall, I
pictures?
just want to
Okay.
remember. So
Yeah.
the deck was there,
2019 was the
and
deck.
so the previous owners put the deck on,
Yeah.
and that wasn't a problem?
I
And
didn't,
then now it's a problem because it's 5 inches over onto your property,
Potentially.
potentially.
basically, in July of 2024, Mr. Bruce decided he would take approximately 70 square feet of my land on, and put his chairs and whatnot on my land, on my, without, so I had my property surveyed. That's what prompted my 2024 survey. That's when we found out that his, not only were his chairs on my property, but his deck was 5 inches on my property, up against my fence, no setback.
So did he move the chairs off your property?
Not until November. It happened in September, the land was staked. He didn't move them until November. He didn't move his set of steps that he left there until I moved them in May.
Go ahead.
I've been dealing with a lot of belligerents.
I would be glad to.
Hold on,
share the
are you done, Jane?
fact pattern.
Yeah, I'm done.
Okay, Steve?
So if the proponent here was agreeable to cut the piece of the walkway that's on your property back,
And the deck.
what's that?
The deck, you're saying walkway, there's a piece of the walkway, that's not a big issue. The deck, yes.
So the deck's actually on your property also?
Yes, I
It's not just in
submitted,
the setback, it's actually on your property?
yes, I submitted pictures. I have them on my phone if you want to see them. I thought
And how much of the deck is on your property? 5 inches?
5 inches.
And there's no way you can work something out between your neighbor on this so that we don't have to make this decision?
This is what I've been dealing with.
We have to
May I,
make
Mr.
it no
Chair?
matter
I
what,
have
but,
tried.
Well, I know.
I mean,
but-
the special permit.
Right, I mean, if they work something out, then,
So based on your plan, the deck and walkway is on your property?
Correct. This is why we don't want to try this issue in front of the zoning board. This is not a zoning issue. You have a plan stamped by our professional land surveyor that shows that the structures are entirely on the property. Unfortunately, they are within the setback. We didn't construct it, but we're here to seek relief. We will have to resolve this property issue with the bandits. But I suggest that this is not the forum for doing that. We dispute the series of events here, and I'm trying to avoid the neighbors fighting.
well, you have to
out-
be neighbors for life, don't you want to be friends? Can't you work it out?
I tried.
Do you have anything, Eric? or-
I just personally, I feel uncomfortable making a decision.
Well, I think this doesn't look like we're ready to decide this tonight.
That's
So
right.
I'm
What
gonna
I'm
ask-
getting at is
I'm
if
gonna
this
let-
was
I
continued.
think Steve's a new member, he needs more time. Honestly, I think, wouldn't
I
you?
don't need more time, I already know how I'm voting.
Oh, you know how you voted?
There's, we have, like,
Are you all
Bob said,
set?
we have a stamped plan. It's,
Well, it
this
sounds
week,
like
this
they
is the
have,
land court.
Grover talk, it sounds like they have two competing surveyors. One saying the line is 6 inches over, and the other one is saying the deck is on site. So, I mean, until that's figured out,
Who are the surveyors?
yeah, I mean,
Well, Rick's one of them.
So if I might suggest, the resolution of this could take years. You're going to park us in limbo with a violation outstanding for several years to resolve an issue that's not related to zoning. It's a somewhat rhetorical question, but, I mean, the whole point of this is to resolve the zoning violation, which is why we're in front of you. We will have to figure out the property line dispute, but that's not
So,
resolved.
so if we just continued and gave you more time, do you think you two could work it out?
I don't think this is going to get resolved in 2 weeks or in the short term.
They already continued it too.
But
Well,
also,
but
the
this
deck
is
is
the new
already
one.
there, you're already using the deck, it's there, no one's telling you to rip it out of there tomorrow. I personally don't feel comfortable approving something that, there's two competing engineers, and to me, you haven't proved to me that that is your property.
I don't have to prove to you.
But that's
that
not
it's
our
your
issue,
property. All I have to present to
But
you is
we're approving the- I'm
is
just
a
looking
site
at it.
plan stamped by a qualified professional that shows it on
And
our
there's
property.
one that's competing that.
And
is
his,
correct.
here are two that compete with your survey.
But we can't decide that anyway, right? It's not within our,
Oh, we can decide that. We absolutely can decide that, Steve.
huh?
It's our choice what we do with the special permit.
But we
We are
can't decide the property dispute. That's not within our jurisdiction, right, Bob?
we can
Yeah,
decide
your,
how-
your opinion is legally irrelevant to where the property line is. I think you should just decide whether on its merits you would approve this special permit. And look at, if Ms. Banda is correct as to where the line is, she can go to court and get an injunction prevent him from using it or taking it down or whatever. None of that is our business. So with all due respect, to stay clear of who owns what, assume that the applicant owns it and let them fight over this in another forum, decide it just on its merits.
Well, I don't know that we should assume that the applicant owns it. I mean, it's not our decision to make, right? So
Well, we're not
why
making-
would we decide either way?
Well, let me clarify that. I think you're right. You shouldn't assume who owns what. Without making any determination of who owns what, the special permit can be acted upon.
Why?
Because that's the law as it relates to the zoning board. The zoning board doesn't determine who owns what property. That's for you and the Bruces to determine in another forum. We have no authority. This board doesn't have the right to decide a property rights issue.
But you can give a special permit to somebody else
What?
on land,
And you have the right to appeal it if you think that the board was wrong.
okay.
If the board grants it. I haven't said the board's going to grant it. This board decides, I don't decide it.
No.
I'm just telling the board that they can decide the special permit. I'm not saying grant or deny, but it has no bearing on where that property line is. None.
And there's no chance of any negotiations between the two of you? It's zero chance?
Again, we've committed to using our best efforts to resolve the issue. It's in everyone's best interest to resolve the issue.
Absolutely.
And
But
how
it's
have,
neighbors.
and how have you done that?
Again, I'm
We have to
not
speak
going
to the
to.
chair.
I'm sorry.
It's okay.
And how has he done that?
Have you done
I would
anything
be
with
glad
the
to
neighbor?
speak on it if you'd like.
None of this is relevant
Yeah.
to us.
Okay, all right.
It is though, Bob, because if we don't have to make a decision that I'm not comfortable with either way, and then they can resolve it, then let them. And then we can give them the permit if they resolve the property issue.
But the one thing I think is pretty important is when neighbors fight over a boundary line, wherever that's going to be, that usually means a lawsuit. Lawsuit is going to take a very long period of time. And in this particular circumstance, if Ms. Bander is correct, and she might be correct, that this is not on the Bruce property, she can go to court and get an injunction or bring a declaratory judgment action to determine where the line is. She could do that in the land court. And she, it's possible that Mr. Bruce won't be able to use his deck even in its existing
But then
location.
this board is putting the burden on her.
No, the burden is on both of them to determine it somewhere else. If you determine it in favor of Ms. Banda based on a property rights issue, Attorney Brodsky has the right to bring a claim and assert that the board determined a property rights issue. And he'll be likely successful on that issue. This is something that happens from time to time with this board. It's happened in other towns. I had it this year in Hingham. And, I had a private client with a property line dispute who was looking for a special permit. And, we told the zoning board of appeals we couldn't determine the property rights issue. It was going to have to be determined in another forum. They decided the special permit issue the way they decided, and then we move on and we resolve the issue. Maybe they'll do it too.
Okay.
You want to talk? Go ahead.
Just real quick, I don't want to complicate anything. I'm Rick Savant with Stenbeck and Taylor. I am working with the other surveyor. We haven't been able to connect officially for a meeting. We've tried on a couple of occasions for a telephone conference to work it through. But we will do that, and we'll get to the bottom of it. Andrew, do you have the other Tom's plan up there?
Rick, if we were to give you 2 weeks or a month, could you come back and, after you've actually talked to the other engineer?
Yeah. I don't want to set a time, and I don't want to, I understand what you guys are talking about tonight, and, I just wanted you to know that I wasn't going to sit here idle while we're talking about it. I'm going to work to get it clarified. There's markers that are out there on the corners of the lot that we used, that have been there. So,
Mr. Chairman,
yeah, and we'll work it out, whatever it is, and if it happens, it's irrelevant to the deck, but I will get to the bottom of it, and we'll rectify.
Yeah, why don't
the
you
line.
both go there and shoot it together?
However
Both
it is,
sides.
we'll work it out with the other, definitely will be meeting with them.
Okay.
That's all.
I don't know what the harm with a 30-day continuance would be. Deck's already there, you're using it.
I agree.
Straight.
Okay, I'm with you.
I agree. All right, so I'm gonna move that, we continue 2542A, Matthew Bruce, trustee, Bruce Family Realty Trust, 8 Ocean Street, but we are gonna need, we'll need on the, Nancy, we're gonna need, on the variance, we're gonna need a continuance signed, right? An extension, sorry. Are you willing to do that? To extend the variance?
There's a pending enforcement request and a variance, and I think you're into that 100-day deadline.
Yeah, so we have to get are you willing to extend?
So there's a certain period of time in which the board must act on the variance application. If they fail to do that, this constructive approval, no one wants to be
We
in a
don't want
position.
that, so we'd have to deny it tonight.
Right. So my recommendation is to extend. I mean, I don't like this process.
I know you don't, but
This process
this is what we're
not fair
offering.
to my client.
I understand how you
You're
feel.
compelling my client to spend more money by requiring.
We're asking you to extend this 30 days. That's what we're asking. It's your choice.
I don't think we have a choice on the extension, but I just want to be clear. It is fundamentally unfair to my client.
That's how you feel.
Yes, Mr. Murphy.
Yes.
That's
That's not
correct.
how they feel.
Thank you.
I'm not commenting on the
I am.
Benda's position, the merits of the Benda's position, their ability to present to this board. I'm just making the point that you're burdening my client to address an issue
We
that's
would
not.
also be burdening them. So
If-
30 days to me isn't a big deal here.
I understand.
That's what you're
Can I
getting.
just finish the sentence, please?
No, but you can extend, tell me if you're going to extend.
We'll extend the period of time for the variance, and they're going to continue it for 30 days. Okay, you're-
Do you agree to that?
If that is the only option, then I don't have a choice.
Okay, so you're agreeing to
I'd be
extend.
glad to give a history of exactly how we ended up
You're
here.
agreeing to extend the meeting
So
for the variance?
But I don't think the board is interested in hearing the
So
history of how it all.
we're agreeing to extend the period of time for the variance. How much time do we need?
And the appeal period, because you brought a zoning appeal as well.
Well, the appeal's been filed.
No, but you asked not only for a variance, but I think you appealed the decision.
We
You did, you
did.
appealed
I'm not,
Andrews.
and Bob, correct me if I'm wrong, there's a defined period of time in which the board must act upon the
Appeal and the variance.
appeal. Thank you.
It's 100 days in both
100 days.
Oh, we should
Thank
just
you.
vote on the
That's right.
variance and vote that down now.
But we can
No,
leave
no,
it
thank you for
open.
clarifying that. I was unaware that there was a specific period of time in which.
We leave it open, Steve, and then he extends it. It's just, it doesn't matter, then they pull
All
it
right.
out as
I
more.
just have another question for Bob.
Sure.
So I understand, Bob, that the land dispute is not within our
Right.
purview. I understand that.
Yep.
But would I be out of line to say to them, why don't you make life easy on us and have both your surveyors shoot it together and make a decision between yourselves, and then have an agreement between yourselves as neighbors, so we don't have to rule against one or the other?
I think
Is
that's.
that all right to say that or not?
I think you can ask the applicant and the neighbors to meet and have their surveyors meet and see if you can resolve this. The problem is, it sounded to me, and you're the ones that decide this, not me. It sounded to me like they've discussed this and it's been going on for a long time and it's not resolved, and, you
I
know.
would encourage you
Well-
to speak with your.
By the way,
Rick said that they hadn't met yet, Bob, so let's at least give the time to let the two surveyors meet, and let's get an answer. That's not a big deal.
okay,
Everyone's in agreement here?
The only thing I just want to point out to the board, the issue of who owns what is legally irrelevant.
We understand that. We just want to have the two surveyors at least talk to each other, not have missed phone calls or missed meetings.
And if
That's
they have
not a
good
big deal.
points to shoot from, it's pretty hard for them to disagree. You got a transit, they're gonna shoot it, I mean, come on.
The surveyors should be able to agree. I agree with you, Mr.
So,
Lynch.
There you go.
all right, so we're in agreement that you're going to give us the extension for time that is necessary on
Correct.
Andrew's violation and the variance.
How much time would you like us to
Bob,
extend for?
what do we need?
When is this being continued
Well,
to?
30 days. We'll do to the, when's the next meeting?
Then ask for a 30-day extension.
Well, we need more than that because we have to answer it and write it.
But you'll decide it that night, and you'll issue a decision.
Can we just take the extension date of October 28th?
Sure. Yeah, happy to agree to whatever makes it easier for.
Okay, October
for everyone.
28th.
So
That's okay?
just to be clear, you're continuing to October 13th for the hearing date? That's
14th.
14th, thank you. There's a holiday, I think, on
And
the,
the date, date to allow the board the extra time would be October 28th.
great. I'll send a letter confirming the extension of those two time periods.
Awesome, thank you very much.
Please try to
Thank you.
settle.
So you
between
won't get
yourselves,
no
so we
more
don't have to-
I know.
notice,
The
you
14th, I'll
understand?
see you then.
Okay,
Thank
thank you very much. Thank you.
You're welcome.
All right, so now we have continued hearings.
Right.
We have to vote on it.
Oh, sorry, continued to October 14th. 2542A, Matthew Bruce, trustee, Bruce Family Trust, 8 Ocean Street. Now we're going to continue to October 14th. Do I have a second? Oh, sorry, both, and Matt, well, I'll do them separately. Do I have a second on that?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Romanzi, aye.
Brian Murphy, aye.
Mike Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
And 2542 Matthew Bruce, trustee, Bruce Family Trust, the variance, 8 Ocean Street. Do I have a second? Oh, continue to October 14th.
Larry Keane, second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Romanzi, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
All right, that was painful. So now we are on to page 4. So we are on to 2541, Michael Mazzini. What's that?
I think you,
Oh, I continued him?
Yeah, continue at the beginning.
And I didn't write it down.
2542.
I didn't write that down.
I didn't write that down, so we didn't do that. So D, 2541, Michael Mazzini, 2105 Ocean Street. We are continuing to when, Nancy?
September 24th.
September 24th. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Steve Lynch, aye.
Romanzi, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
All right, so now we have 2540 Rick Holstein, Progress Way. Petitioner is seeking special permit in accordance with, oh, these are continued, right? I don't have to read
Holstein's
this.
not.
Oh, is this new? Oh, one new and one old. So, special permit in accordance with 305-1010 of the Marshfield Municipal Code to construct a 28,000 square foot building, indoor athletic facility, which is allowed under the Table of Use Regulations, Community Facilities 17, and site plan approval under 305-1202 of the property located at Progress Way, which is further identified on the assessor's maps as being on parcel D0901-130, is located in the I-1 zoning district, land mixed use overlay. Name and address for the record.
Rick Holstein, 1 Atlantic Street, Marshfield, Mass. 02050.
Yeah, this is these are both continued.
Yeah.
Yeah, I didn't have to read that. All right, go ahead.
Good evening, everyone. I'm Attorney Steve Gard, 1165 Washington Street in Hanover. I'm here on behalf of the applicant this evening.
Kevin Grady, Grady Consulting, 71 Evergreen Street, Kingston, Mass.
So I think although I was not here at the last meeting or the meeting before that, I think that I was asked to come in and help sort of explain the parking situation and to help the applicant reach some sort of conclusion with you folks. My understanding was the concern last time was that there was not enough overflow parking. You were concerned about overflow parking and the parking demands. I submitted a letter dated September 5th, 2025, with an analysis and a proposal that I was hoping the board might have a chance to review. And I think it sort of spells out a pretty logical scenario for Mr. Holstein and his property. My understanding is from the last meeting that the board was willing to grant the special permit to reduce the 80%, but only to allow it on the sides in the rear of the building. So to that extent, we picked up 4 spaces. The plan that you have before you this evening has reflects those 4 additional spaces. We've also identified a loading area, which is required under the bylaw as well, to the rear of the building, typical for deliveries and whatnot. When I did the calculation for the space itself, my recollection was the building totally came out to 40,388 square feet, some of which was recreational space and some of which was office space. So what I did was I went to the bylaw and I looked at the way we typically calculate these things. For like a warehouse, you have to allocate certain parkings for the office and then certain parking for the warehouse. So I did the 1 in 400 for the athletic space, and I did 1 in 500 for the office space for the 6,800 square feet and change. Came out with 98 spaces required under the bylaw, regardless of any reduction in spaces. So that saved 3 spaces there in the sense that it was, my understanding was the board thought the parking requirement was 101. So what I proposed in the letter was 13 spaces would be allowed off-site. The first section of your authority comes under the site plan approval for the spaces allowed within 300 feet of the premises itself. So what I proposed was, and Mr. Holstein has the space that's next door, and it's well within 300 feet of the space of this site premises, as it is listed under the bylaw. And what I proposed was that Mr. Holstein's space, being an industrial use building, would have spaces available in the evenings and the weekends, right? We all know that. I did this in Braintree with the Flatley place for the lacrosse fields. They're empty on the weekends. So my proposal basically says, let's allow Mr. Holstein to lease 13 spaces to the athletic center for evenings and weekends. And then within 500 feet, the board has the authority under a special permit to grant the use of the public spaces. Having really thought about the public spaces up on the hill with the ball fields, those aren't gonna help us on the weekends, right? Because we know those are pretty busy, and they're probably pretty busy after work for, ball field practice and games. Maybe in the wintertime they might be, but, so what I proposed was just allocating those spaces Monday through Friday, 8 to 4, when Mr. Holstein's commercial business is being used. So it's kind of like a hybrid. I think it works for everybody. It seems like a really cool project for the space, and I think that would, in my opinion, it's a reasonable solution. We could use signage and directions to make sure people know where they're going when there's not a sufficient parking on site, and we're only talking about 13 spaces overall. So I think that it'll probably come into effect, maybe if there's like a basketball tournament on a weekend, you might need to direct those people, but again, they're gonna be directed to the property that's right next door, and that's where they can do the overflow parking. So I hope that I explained that correctly in my letter. I know my letters can get a little complicated, but I tried to, boil it down to the board's authority based on what I saw in the bylaw, first being through the site plan approval, the second being the special permit. We're not asking for that special permit to reduce by 80% altogether at the end, as I mentioned in the letter. So it's really those 2 mechanisms to help Mr. Holstein's project work from a parking standpoint.
Okay. Bob, do you have anything to add to this?
Yeah, I think I just caution the board.
You could just caution the board with that public space out there. I didn't know that the plan was to have basketball tournaments there, and I guess that kind of prompts the question, is it going to be a cafe or some type of a food service facility indoors? Because that might affect things. I mean, some recreational complexes that are different from a gym have significant traffic draws, particularly around tournaments, and if you need any example, look at Starland. And I'm not suggesting that this is a Starland, it's just not big enough. But
No.
when you have tournaments, it tends to jam up traffic, and if it's a youth tournament, it's probably going to be on the weekend, and that's when those fields are busy. I think it's completely appropriate for the board to consider whether to grant the special permit to use the abutting parcel, and grant the special permit there if you feel that that's warranted. And if you do that, I'd suggest that there be a restriction placed on that land in the event that the title is in 2 different names or an easement granted, so that parking spaces will forever be connected to that abutting parcel. It's up to you what you want to do. Just be careful when you're authorizing the use of town spaces.
So
Would
again,
that be an issue with an easement on the property?
yeah, we kind of do, because it's a permanent restriction. So what we would like to do is have a lease, that the lease particularly spells out that if the lease is terminated, that the town gets notification, that the lease would be a condition of the approval before we get an occupancy permit. The way we've done it, I've done it in the past, I did it at Rote Marine and I did it at Levitate, it was all leases. The board didn't require an easement for those in the past, under this particular bylaw.
Yep.
I will say this, that I understand Bob's position, and I think that we're only asking for the public spaces to be, quote, allocated on paper Monday through Friday from 8 to 4.
As needed.
Yeah, just from Monday to Friday, 8 to 4, not on the weekends, not after work. Mr. Holstein's other business will take care of it.
Now, would it be something with a lease, if you wanted to cancel that lease on those spaces, that would have to be approved by either the town at a later
Yeah,
date? Because
I
say
mean-
there's a parking issue going on there, and you decided to sell the building, and wanted to cancel that, and there's
Yeah.
already a parking issue.
Yeah, so what would happen is the special permit's gonna get recorded in the chain of title for this particular property, and it's gonna require a lease. So anybody that sees it on the other side, the lease would be required to be recorded on the other side as well. So it's gonna have the same effect as an easement, it's just not gonna go on forever and ever and ever. And if down the road, if we find after 2 or 3 years of this, and we notice that this
You don't need it.
Doesn't get needed.
just don't need it, it's easier for us to come back to the board, ask for a modification, and then we just get rid of the lease issue. You know?
Would that be appropriate, Paul?
I actually don't think a lease is appropriate, and I hate to disagree with Attorney Guard, but in this case, I do. I mean, if you're going to have a facility that's going to need more parking because our bylaw requires it, that has to be in existence. If they change the use or it's plainly obvious after a year or two that they have no traffic problems, they could come back and ask to modify the decision to eliminate the requirement for an easement. But if it's in any potentially required, the easement is the only way to perpetually require that. And
Acceptable?
I mean, I'm not recommending it to the client, we did talk about this, I think it's a burden on Mr.
Because I had mentioned that at the last meeting.
Yeah.
I brought that up, that if you did put an easement on the property, and I need clarification, Bob just clarified it there, that if you did take an easement on the property in 2, 3, 5 years down the road, it wasn't being utilized, and you had other plans for your building, you'd come back in and say, it's clearly not being
Right.
utilized, and the town could agree and eliminate it.
I can see where at the end of the day, it's having the same result.
Yeah.
You know, I agree with Bob that it has the same result. I don't think it's necessary to do the lease, to do the, only because that's what we've done in the past, and the board didn't require it before.
Yeah.
So I'm just going on past precedent, which I understand you're not bound by. You can do whatever you want tonight. But I would think that the same thing can be accomplished in that regard. You're talking about two, reputable businessmen in town that, they know they're gonna have the lease, it's gonna be
Absolutely.
entitled to the
I
property.
think this is a great idea for
Yeah,
this property.
there's no way to get around the parking, and I know Bob is, this is required, like, the spaces are required, but it's within the board's discretion to allow by special permit, to allow this sort of, adjustment to the parking requirements on site. That's why.
Let me get clean here. There are 81 spaces around this building right now, as
84.
planned.
84.
There's 84 around it. If we just, within our purview, say we can reduce it to 80%.
Yep.
That's 78 spaces.
Yep.
So you're already over by 6.
Right. Yep.
So, and what you're saying is that you're willing to go above and beyond and add an additional 13,
Correct.
just to get it up to the normal 100
Yes,
through this lease arrangement.
correct. You said it better than I did.
Let's just get clear here.
That's exactly what it is. We are, if you were to truly take the 80%, which you have the authority to do under the special permit.
That's 78
We're
right
above
there.
that already.
You're already above that.
Correct.
So, thank you for that. I appreciate that y'all went back, redid your plans, and took that in consideration. And now, what you want to do is you just want to add an additional 13 to get you back up to that 100% level.
Correct.
And you're going to do it by,
Leasing spaces next.
right, by time shifting.
Yeah. Yeah.
Got it.
Which is appropriate in an industrial park, because.
I think that's an
different
elegant solution, personally.
uses. Wow. Thank you.
Bob, are we
ahead,
sole
Steve.
granting authority here?
You are, yeah. And just so we're clear, what happens if Mr. Holstein is not involved anymore and the owner of the other building decides that I'm canceling the lease? And what happens if you need that parking spaces? What do you do then?
Right.
We're out and we have a parking problem. That's why I'm suggesting an easement be granted, because they're asking for you to give them relief from the bylaw, because our bylaw actually requires more parking than they're actually showing. And yes, you can grant them a reduction, but if they're having tournaments and there's something else,
80%, that's where we can give them a reduction, that's what the bylaw is.
you have the right, if you're convinced that there's cause, to give them a reduction. I don't know what's going to happen there. They could be absolutely right, they're never going to need all these spaces. But if they're wrong and you don't get ahead of this, you're probably not going to be able to.
So what are you suggesting?
require it. I'm suggesting that if you grant the special permit allowing them to do that, that an easement be secured so that that right to park there will continue to exist perpetually. And if they want, your board could actually add this as a condition. The board could say, we will review this in 2 years or 1 year to determine how things are going. And the board could affirmatively say, if you satisfy us that this isn't required, we'll amend the condition and release it.
Yeah, that makes sense to me.
And that green space in the back's impervious.
Anyone else on the board?
Pavement.
Yeah,
Most spaces.
agree. Anyone else want to say anything? Anything from the audience on this? All right, are we comfortable with this now?
Yeah, I mean.
I am, I'm ready.
I'm comfortable,
Yeah.
I have to agree with Bob, with the easement, but with the condition that a couple of years down the road, you can come back in and say, we haven't needed this overflow, we're doing tournaments, everything's great. I'm all for this project, but we
I
feel
think-
the responsibility with it, you know?
You'll be
appreciate that.
wordsmithing this answer, Bob.
I think that, when I said tournaments, you get the immediate connotation of
I
Starlight.
hope without tournaments, you're
But-
busy enough that you need
Yeah,
all the parking.
but there's only
I
two
hope the
basketball
business
courts
is that
here.
good, yeah.
There's only 2 basketball courts. So
Yeah.
it's unlikely that these tournaments are gonna have any giant impact. They're gonna be
Yeah.
teams playing on the weekends, which we're hopeful,
Yeah.
youth organization.
Hopefully, a couple of years down the road, if your business is expanding from what you got there, it's great for everybody. You get
Yeah.
great for you, and
I mean, it's,
obviously, you're making a huge investment. You're gonna want the business.
they're gonna issue the permit with a condition. I
Yeah.
presume they're gonna issue the permit with a condition for an easement. So you will have the opportunity to appeal that condition if it's within your, if you'd like to. Otherwise, it sounds to me like I'm not speaking for the board, but it sounds like that's what we're gonna get. I don't think we're having a choice.
Kevin, is there any way for us to get pervious products and take up some of that grass and still call it green space? And gain 10 parking spots? I mean, that's,
I don't-
is that what we
that's-
need? That's
We need 13.
13? Yeah, you're not gonna make it.
I don't think there's
Yeah.
room in there, and I'm not sure that that's been allowed by the board in the past.
Do you want more time to think about it, or?
No, we've been taking up too much time as it is. We need to start
Up to
this
you.
question.
Right, I have one more question for Bob.
Yeah.
So,
I think that,
so
We're
if
gonna have to go for it. Yeah, yeah.
If we put that condition in that you said, Bob, right, they don't have a right to appeal that part of that.
They have the right to appeal any condition
Any
that
Yeah.
they want. They
Just
can
the
take issue with
specific
that.
condition.
But the reality is, if they appeal and they're successful, you can then decide not to give them the special permit.
Then we're back on that side.
I mean, look at it, if everybody's familiar with like the Stop and Shop in Pembroke, and the Lowe's over there, the parking requirements in Pembroke would require literally the construction of a parking garage to make all the Lowe's work. So what they did is they showed a design that showed all extra parking, and then they said you didn't have to build it yet because we're gonna trust your empirical data that says you don't need as many spaces. And if you had to build it, then you have to use it. I mean, if you want.
But that's all private property over there, right?
It's all private property. Yep. It's all private property.
here.
Yeah.
Yeah.
This is all private.
You could, you could look at it from that perspective, too. You could review the special permit in 1 year to determine whether the amount of parking that's on this site is sufficient. And if it isn't, they'll be required to come, you could reserve that.
Right.
If you want to look at it that way.
You could see what was going on for the
If you
next
want
2
to,
years.
if you want to do it that
How the
way.
parking was working out.
So we
It
could
was
do that
overcrowded or
without the
not.
easement.
You could,
What you're
you
saying.
could examine the parking situation a year.
In a
You
year.
could give the special permit, make a condition upon a review of the parking circumstances in 1 year. That's an opposite way of looking at it. If you take their word for it and say they don't need this stuff, you could say, okay, prove it, and we'll see you in 1 year.
Well, it'd be obvious, like, look at Lowe's, they barely use any
The
of
the
it.
only problem is if Mr. Holstein doesn't own the abutting property at that time, and by the way, we all want him to be successful on this thing, and so it's not about that at all. But if he doesn't own the other property, then you won't be able to guarantee that they can park on the other on the other site, unless the abutter gives permission, so.
But if we did, but that's a good point, Bob, and I appreciate you heading down that path. But I think we're still willing to do the lease, and if he sells the building next door, it's gonna be something, when you buy a
Yeah, but what
building.
happens if you terminate the lease?
No, it wouldn't be, it can't be terminated because it's part of the condition of a special permit.
But a lease
On-
is always terminable.
I'm just I guess what I'm saying is that I'm suggesting that if you want to go the path of granting the special permit, taking our word for it, and then revisiting the parking in a year, I'm saying in the interim, we'll still do the lease for the 13 spaces, you know, and still look at it in a year, like Bob suggests. Or you just want to issue it without anything, conditions?
Somebody else's
That's fine
property.
too.
He owns both properties.
He currently owns both,
Currently owns both.
so he can do
So
it.
if you sold it, then there's a problem.
Then there's a
Correct.
problem.
Well, what they're saying is that there won't be a problem because the lease is still conditioned.
It'll be subject to the sale will be subject to the lease.
But I'm comfortable with the fact that an easement, in a review, if we did 12 months from the date of occupancy, 1 year after you open the doors, if you come in and there's no parking issues going on, everything's great, then the easement could be removed.
Yeah, we could do that on our own volition, so I'm not sure what.
But if you came back
That
in front of the board and you came back a year after occupancy, come back in, there's no parking issues, everything's fine, the town isn't running into any
Well, what
issues.
Bob was saying was exact opposite.
Yeah, that's what I thought.
Prove it as is.
Look at that, I just think that you need to ensure,
Just
if
think-
you're gonna allow them to use an abutting property, that there's a legal right to use it. And if they lose the legal right, and maybe we let them decide how they wanna secure it, then they're gonna have a problem with their continued use of the building, and their special
Don't you
permit
add
is
that
at
to the
risk.
deed?
What?
Don't you add that to the deed?
No, we would add it as a condition in the special permit.
Which
Okay.
is attached.
What's the number for 100%?
98.
And you're at
80.
80%?
Yes.
Yeah, we're at.
Well, you're at 80.
Above 80,
85.
we're at 84, 85,
Yeah.
so that's well, above 80%.
So you're at 85, we're allowed to reduce it to 80
Which is
within
78.
our,
78,
so
actually.
why are we even talking about this? Let's just, do they need the extra parking?
I
If
don't
we-
know.
We don't know yet.
If you're
What do
convinced,
you, running the
We
other
don't anticipate
building,
that we would need the extra.
with the other gym, do you need, what do you use, how many parking spaces do you use
That
there?
would be Ed's, would know that, but obviously the other gym area where he's moving from
It's small.
is a smaller facility.
Right, but how much, I mean, you can,
I mean, I typically see 11 cars over there, 12 cars over there, 15?
Yeah, I mean, it's
so you could correlate the
very
space.
dependent on the time of day. You know, I think we have.
So how much bigger is this space than that space?
That space is 6,000 square feet.
The new space
The space
he's currently in?
yes,
And how big is
So this
this?
is 8 times bigger.
40,000.
4,000.
Well, with the
Including with the basketball courts,
the-
inclusive of the basketball courts.
Yeah, the health club, the gym
Is
part
about-
of this is not
Right.
even that big. It's not 6,000 square feet. It's not.
So even if you just did that, at, you know, at 88 spaces, it seems that it would suffice.
What do you think about that?
So I'm looking,
As far as 80?
I'm looking at the Boys and Girls Club right now. They have 2 basketball courts on the weekends. They're busy. And their
Fields.
their parking lot's packed. They only have like 30 or 40 spots. This is the
See, we're
same
good.
size facility. We're giving them double spots. If we reduce it to 80%, I think it's a no-brainer. But
I think that, I agree, I think that makes sense.
I don't see the reason to force them.
So we would, if we were to do that,
Use another property.
we'd have to give the second special permit for the 80% reduction, Bob?
Yes, and that's within your purview. It's really
Yeah.
all up to you all.
That's my theory on it. Like, I
Well,
feel like it makes total sense.
We can close it and talk it. I think we know what we're doing, maybe. So, you guys ready?
Yep.
Steve, you got anything? Eric? Everyone done? Anything in the audience done? All right. Well, it's on a move that we close 2540 Rick Holstein Progress Way. Do I have to close both, Bob? 2540A Rick Holstein
Yeah, I'd close both of them.
Progress Way as well. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Stevens, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
And then 2540A Rick Holstein Progress Way. Second to close that.
Second, sorry.
All in favor?
Larry Keane, aye.
Stevens, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Gene?
Jean Lee, aye.
Closing the hearings.
Yes.
Yep.
Eric Murphy,
When
aye.
the voting is taking place tonight.
Right.
Because
I'm gonna have to say that I-
Make sure you identify
Right,
who the
so-
voting members are.
The voting members on this will be Larry Keane, Grover Hensley, Brian Murphy, Mac Brothers, and Gene Lee. Because they missed too many meetings,
If
right?
they've missed more than one meeting, then it should be
Yeah.
as you said.
Okay, all right. But we can all discuss it, so.
No, everybody can participate.
Yeah, discussion. All right, so you guys ready? What do you think?
Can I just make a suggestion?
Sure.
That we do that before we open up a hearing, that we decide, tell everybody who's gonna be the voting members.
Sure, but standing is that the associates, they vote just to give their opinion, but the 5 full-time board
But
members.
just so that,
Well, that's what we're doing this, we're letting them know.
right,
who's
I know, but
voting.
we should make this available at the beginning, of when we hear evidence, who is gonna be the actual members to vote to make a decision.
Okay.
You know, I mean, I understand how you let everybody vote and so, but,
Right.
you know,
Yeah, where you don't have your nameplates in front of you and as an associate, I think Mr. Lynch is right. You should say.
These are the voting members.
On this matter, so that it's clear.
yeah.
All right, so what do we think on this? I'm happy with everything, and I think the 80%, I'm okay with that. That goes to 78, but we can request the full, what do they have 84?
I think it's 85.
85, so we can request we're reducing the 80%, but we are requiring 85 parking spots. In my eyes, at 88, this is covered, so.
I'm all for this project going through. I think it looks fantastic. I think it's a great use for the property. I agree with Bob, we need to protect the parking. There's been so many issues up there with other projects going on. I can get not doing the, doing a easement on the deed, so if there is a lease written into it, that would be part of the order of conditions. That would satisfy me, to make a concession to make this.
So the lease,
project
you're accepted in the lease.
A parking lease for an off-site on Mr. Holstein's other property.
Okay.
As part of the order of conditions.
Steve?
I'm all set.
Oh, you don't, nothing to add?
I'm not voting, so.
No, but you can speak on the project.
Well, I'm all for any type of athletic facility, of course.
Okay.
Got to get the kids out of their room with their cell phones.
I agree. Thank you.
You got my opinion. I
Yeah.
think that the 80% would be fine. If you're willing to do the lease, I think that is an extra layer of protection for the town.
Yep.
And it makes sense to do it if you guys are willing to do that.
I'm 100% with Grover on this one. I think 80% is fine by me, just period. But if y'all wanted to add that extra belts and suspenders by putting that lease on for that extra 13 spaces, thank you.
I agree,
Okay.
thank you.
Wonderful.
Eric?
Yeah, I agree. I'm all about the parking. If you can add an extra 13 spaces that are overflow, you know, if you get a rainstorm and there's a puddle in 2 spaces and you lose 2 spaces, then you get a little overflow. So, I mean, I agree. If you could make it happen, more parking the better. It's not gonna hurt.
Okay. I gotta add too, I appreciate the fact of the investment you're making in the community and what you're putting there and the effort you've gone through to satisfy this board with your parking concerns. Very good.
Thank you.
All right, Bob, so now you can be the wordsmith on this.
So you're, of the voting members on this matter,
Yep.
are at least 4 of the members, from what you've said, in support of granting the reduction.
I believe so.
Yes.
So we're gonna have to do both.
We'll do both,
Yeah.
but let's do the parking reduction vote
Okay.
first. Okay, so the motion would be, I move that the board vote to grant a special permit to Mr. Holstein in accordance with section 305-1010 of the Marshfield Municipal Code to permit the reduction of parking spaces to 80% of that required in the table of off-street parking regulations pursuant to section 305-8.08M on the property located at Progress Way, identified on the assessors maps as parcel D09-01-130.
Should we say there's the existing 85 spots there, so it's not 78?
I was gonna say 80% plus the 4 handicap spaces,
Okay,
okay?
because they have 85 currently on this plan.
Well, then you could reduce it to. 85? Parking space requirements to 85, which is greater than 80%.
80%, okay.
Okay,
That's
so that
fine.
would be the only amendment.
All right.
Okay, and that would be the motion.
All right.
Subject to conditions.
I'm adopting Bob's amendment.
You want to add a condition?
Whatever you guys want
Is
to add.
that the condition for the lease?
Andrew, do you need like the building permit and that stuff in here? It's only, this
If you're
is,
reducing it to 80% or just over 80%, you don't need it.
Okay. Yeah. All right.
And they didn't vote?
Yeah, since it's site plans, or because it's special permit, it would just be, building permit and, final as-built and certificate of occupancy.
Thank you. All right, do I have a second?
Second. Larry Keane, second.
All in favor?
Larry Keane, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
All right, so now,
So now you're gonna do the overall project.
right.
I think I gave you a motion on that, on your meeting minutes.
Tonight? These
Yeah,
ones?
it's on page 29. The motion to approve the project, to make sure that the plans are the latest plan date. Mr. Grady should confirm that.
Oh,
We have to go with Lisa.
so the proper plan date, is that April 18th, 2025? Or has it been changed,
I
obviously?
think there was a change. What's
Yeah, so
that?
I have May 22nd, 2025, the original, revised 7/11/25, and revised January 25.
So the most recent one is 9/8/25? So that's the one I'll go with.
You want me to send you that?
I have it right here, Bob. I move that the board vote to grant the petitioner's application for site plan approval, subject to the conditions, obviously, like Andrew said, a building permit, site plan, and certificate of occupancy, based on the findings that the applicant's proposal to construct a 28,800 square foot building for the indoor athletic facility as shown on architectural elevation and floor plans for exterior view, first floor mezzanine, level 80 architects, Canton dated, is that the same, March 12th, is that the correct date on the architecturals?
It must be, Brian, I don't.
Okay.
I think my memory was there was some preliminary, and then there was a
Well, I got it here. So
further rendering.
12th, 2025, first floor, an updated preliminary design, April 18th, 2025, by Antonio Donato,
Just had a
RA.
That's what I have in past report, it says April 18th.
Date. And site plan for Lot 26 Progress Way, Grady Consulting LLC, dated 9/8/25.
It should be dated May 22nd, 2025, amended through.
Oh, okay. So dated May 22nd, 2025, amended through 9/8/2025, by Kevin Grady, PE, and Timothy Bennett, PLS, 10 pages, meets the performance standards, design objectives, section 1202 of the bylaw. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Thank you.
No, we
You
still
missed
need
one
the
other
special
thing.
permit.
What's that?
You did the site plan approval.
Yep.
Now you have to do the special permit.
Oh, underneath.
The special permit was on page 29, and you just read the special permit one, which is fine.
Yeah,
So
I did site plan approval,
you did site plan approval, correct?
so now I got to do the special permit.
That's
So I move that the board vote to grant the petitioner's application for a special permit, subject to the conditions, plot plan, building permit, certificate of occupancy, based on the finding that the applicant's proposal to construct a 28,000 square foot building for an indoor athletic facility as shown on architectural and floor exterior view, mezzanine level by 80 architects of Canton, dated March 12th, 2025, and updated on April 18th, 2025, by Antonio Donato, and site plan for Lot 26 Progress Way, Grady Consulting LLC, dated May 22nd, 2025, and updated through 9/8/2025 by Kevin Grady, PE, Timothy Bennett, PLS, 10 pages, meets the special permit criteria, section 1010 of the bylaw. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Grover Hensley, aye.
Brian Murphy, aye.
Mac Brothers, aye.
Jean Lee, aye.
Thank you.
Is that- Congrats.
Now, is that all we have? Good luck. Other than the,
Good luck.
thank you, guys.
Yeah, look forward. Be nice.
That's everything except for accepting the minutes and all the other stuff that we carry like a weight every meeting. Okay. So I'm going to, Larry, go ahead, you can do your approval of minutes.
I make a motion to approve the minutes for June 10th, 2025, and June 24th, 2025.
Second?
Larry Keane, aye.
Grover, sorry.
Steve Lynch, aye.
Grover Hensey, aye.
Brian Murphy, aye.
Eric Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
So that's it, right?
Yeah,
Nancy?
can I bring
Motion?
something up?
Oh, no, go ahead.
I just wanted to, I don't know, I didn't hear anything, I don't know any different, but who are the associate members now?
Oh.
And who are the permanent members now?
So the select boards, Steve and Eric are the full-time members. Jean and Mac are remaining as the associates.
Did they give a reason why they did that?
They did not.
Isn't that unusual?
Yes, it is, but,
That's what I thought.
oh, sure, go ahead.
Heidi Conway, Module Street. According to the Select Board last night, Eric Kelly said that you, Brian, had said they didn't want to move up, which I know is not true.
That's not true.
But you had said that that was the case, and that was the reason why they were made permanent members, that Mac and Jean had said they didn't want to. So I just want that on the record, that that's what was said last night.
I did not
And
say
here's,
that.
and this is not like a slight against you guys, I look forward to working with both of you.
Hey,
I just,
I'm a politician, it's a blood sport, you don't have to worry about me.
these guys sat, everyone that was on this
did.
board sat as associate members to watch and learn and I had no idea what I was doing when I started. I'm not saying you don't, but I learned a lot. You saw everything that happened. These guys put their time in and they kind of got screwed, in my opinion.
But
And it's not,
just for the record, there were 77 appointments by the Board of Selectmen for boards, and 4 people get changed. So, you know what, just be crying about it is ridiculous.
I'm not crying about it.
I'm not saying you are.
I'm not crying.
I'm not.
I'm not crying.
I'm not
I will
saying
tell
you.
you, for the record, no one ever asked me whether I wanted to move up or not. So,
Okay, I didn't mean
Can I make
to point this at you. I meant to point this at the forum.
It's not on your agenda.
yeah, sorry. Again, it's nothing against you guys at all. I wanted to be on the
Okay.
record.
I just wanted to clarify that point, though,
Yep.
because people have been saying online and so forth about how, it was all political appointments. Well, that's just not true.
No, you guys are lifetime residents, you know?
They
I'm
asked
happy,
for
and
volunteers, I put my name in, and here I sit.
And again, it's not
4
you
out of
guys.
77, that's what.
But I think after the meeting, we should just hug and sing Kumbaya, okay? So, on a motion to adjourn,
Larry Keane, second.
all in favor?
Larry Keane, aye.
Steve Lynch, aye.
Grover Hensey, aye.
Brian Murphy, aye?
Mac Brothers, aye.
Jean Lee, aye.
Eric Murphy, aye.
Thanks, guys.